to take a couple of minutes and just further discuss some of the questions that we received after today's webinar regarding the PPP program, the forgiveness of the PPP loan program, and some of the guidance that has been recently issued by the SBA regarding the PPP program. First, we received many questions regarding the payment of bonuses. As discussed on the webinar, the payment of bonuses, incentive pay, and hazard pay to employees during the covered period will be considered an eligible payroll expense. However, employers should be mindful of the $15,385 cap per employee compensation that was indicated in the forgiveness application previously released by the SBA. Therefore, employers who are looking to pay employees bonuses or hazard pay or some sort of incentive during the covered period should be mindful to not exceed that cap when determining a bonus amount, or the excess will not be considered an eligible expense. Also, on the topic of expenses, we received a few questions regarding the payment of expenses outside of the covered period. As briefly mentioned on the call, for non-payroll expenses such as utility bills, the covered period, let's say for example, starts on May 1st and goes to the end of June for those 8 weeks. If the employer's utility bill for April is due in May and is paid in May, then that bill, according to the current SBA guidance, would be covered in full for the forgiveness amount. For June, for May that's paid in June, will also be covered in full for the forgiveness amount. And any amount at the end of June that's outside of the covered period that's then paid in July prior to the next billing date, the prorated portion for that bill will also be covered will also be part of the covered period. So employers should take an eye out for their billing dates, and of course look at their documentation and retain documentation showing the billing dates for when utilities were both incurred and paid during the covered period. We also wanted to discuss a little bit more about the DeMinimis exception to the FTE headcounts. This exception applies when FTEs are either terminated for cause, voluntarily leave their position or resign, or when employees who were previously furloughed refuse to come back to work. With the FTE headcount calculation, it is typically an all or nothing test. So this exception is beneficial to employers by not penalizing them on their forgiveness application for employees who are refusing to come back to work or are terminated, either because of cause or because they leave voluntarily. For employees who employers make offers to return back to work after a furlough, those offers need to be made in good faith, they need to be made in writing, and they need to be for the same amount of pay and hours that the employee was previously working. If employers issue an offer and that offer is not accepted by the employee, there's also a new requirement that in order to claim this exception on your forgiveness application, the employer must notify the local state unemployment office of the employee's refusal to return to work, thus affecting the employee's unemployment benefits. We hope this additional clarification and information from today's webinar is helpful. And if you have any further questions, you can feel free to reach out to myself, Jeffrey Shear, or any of the other business attorneys that you normally work with.